Hi everyone, my name is Jeff Kahane with Kahane Law Office, and I'm here to talk to you about residential purchase contract. It's important, an important document. A lot of people see it as a form to get a home. However, the purchase contract is a legally binding contract. It's a contract that's going to buy a buyer and a seller, and it's going to create obligations on both of them that they have to do. So if they don't understand it, or if you don't understand it, it's going to be important for you to pay attention here and also explain things to your client. Now, when I have a group of people in front of me and I ask, who's read the entire contract through line by line in the last 6 months? Inevitably, the response rate is 10, maybe 15%. If I'm going to give you any homework today, I want you to go through that contract once a quarter, twice a year even, and read it line by line. And that's going to be good for you, one, in terms of your knowledge of the contract, two, in terms of if you're making changes to the contract so you know which parts tie into other parts of the contract, and three, just from a negotiation standpoint and a client service standpoint, you're going to be able to do a better job. So try and commit yourself to that. It doesn't take very long. I still do it, and I deal with this contract every day over and over and over again. And each time you just remember one more thing in the back of your head, so important. So let's go on with looking at it. Our first blank. I've been asked, Jeff, you're doing these presentations on how to fill in the contract, how to understand the contract from a legal perspective. How can you possibly spend any time on the name section? It's a name. How can people screw that up? People do all the time. So if you're acting for a seller, you're going to want the name on the contract to match the name that's on title. And if the person's identification, and yes, you need to not just take the identification, you need to look at it to make sure it's the right person and that the names match. If the names don't match, ask for other ID. So if someone got divorced or they got married and their name has changed, you can't just take their word that they are that person selling their house. You need to be able to trace it through. We're going to have to as lawyers, and so it's better if they don't have that ID for them to order it right away. And let me just throw in just a tidbit for buyers. Buyers are so excited to get their new home. They'll often run to the registry to change their address. And from the registry, they get a little temporary piece of paper that says, this is not ID. Maybe suggest that they do that after they see their lawyers. I know it's a little ways down. Just we need to get ID or we can't get bank financing. We can't get them sign their paperwork. If they have a passport, great. We've got a second piece. But just a little heads up for buyers. Buyers also, speaking of them, you have to make sure that their ID, you should look at their ID and match it on the contract. It is not good to put in the contract R. Smith or Jeremy. You need to have first name, last name, and that's really who the person is so that they are bound by the contract. When you're dealing with a corporation, it's a whole other can of worms that can come up. You need to make sure that the full legal name of the company is what you're putting into the contract. The Inc. Ltd., the ending of the company name is so important. It needs to match. How do you make sure it matches? Pull a corporate search. The corporate search is going to tell you a couple of things. One, it's going to tell you exactly what the name is. Two, it's going to tell you if it's actually still a company. There are times where a company gets struck, and if the company is struck, then there is no legal entity. There's no ability for the company to sign off on anything. If it's your listing, you can't get your commissions because it can't legally be bound to a contract. So you want to make sure that the company is in fact active. It's going to have to be down the road anyway. All that can be fixed. If it's not, better to fix it in advance than afterwards. Once you have that, you also want to make sure you have the right signing authority. We've had situations where agents say, we don't know who can sign for the company. We just had the accountant do it, literally. And that doesn't work. You need to make sure you have the person with proper signing authority. If there's one shareholder, one director, and that person is signing, that's going to be a no-brainer. If you don't see this person signing his name on any of those documents, there's a problem. You want to make sure you have the paper that shows that they're okay to do that. The property. So we're going to talk about legal description and municipal description. These are key because that is what is being sold. You want to make sure that this information is absolutely correct. We've seen people put the wrong municipal address. We've seen people put the wrong legal description. Condos, a little bit worse than houses for whatever reason. We'll even go through with the condo plan and confirm with the client, is this your unit? just to make sure. We've seen builders mess it up, we've seen home resales mess it up. It's going to be really key that you get that right legal description and the municipal address that is correct. Some communities, they've changed the names of the streets. It doesn't happen often, but if it does, you don't want to use just a prior listing information. You want to make sure you're using the actual new information for all around, and it's going to be key. Unattached goods. So unattached goods are chattels, things that aren't affixed to the house. They don't come with the house unless you write it into the contract. Sometimes that can work the opposite way. For instance, people leave garbage in the house and old desks, old freezers. It's not supposed to come with the house. So your buyer or your seller is going to have to haul that stuff away. And if you've told them, oh, don't worry, leave it, it's no problem, it can end up coming back to bite you. Worst case scenario, we had an agent who was representing a hoarder. House was being demolished, it was in the inner city, and we were going to put in an infill. And the agent said, don't worry, just leave all the stuff, they're going to be bulldozing and taking it all away anyway. It ended up costing the agent about $8,000 to pay for having all the junk removed, because the builder had no interest in going through literally feet of garbage throughout the house and the backyard. It was up to the doorknobs in most places. So you just want to be cautious with that. When you're filling out this part of the contract, you want to be specific and make sure that you catch everything and that you don't miss it if the contract's going back and forth between buyer and seller. Days are gone where people are writing them in. It's usually more electronic, so there's less things missed in terms of them being dropped from previous versions of the contract, but often they're left out altogether. We'll have an agent who's missed this come to us and say, but Jeff, it's in the listing. They get it. It comes with the property. The answer is no. The listing is what is available for sale, not as what is being sold. It's the contract that determines that. Your purchase price is usually not the same price that's in the listing. The listing of things in the listing are not usually at the end of the day what the person is getting. It absolutely comes down to the contract. So if there's more than one washer and dryer, you want to make sure you specify which washer and dryer the person is going to get. It is a good practice to put down the brand or model number of the washer and dryer, fridge, stove, just so that there's nothing being swapped out. It happens occasionally, and usually we'll then call the other lawyer and say, hey, your client took the fridge, we want it back. Usually we get it back. Sometimes say, no, that was the one that was there. It was there. So unless there's some kind of proof or something specified in the contract, it becomes difficult. We don't want to end up in those arguments. As technology has changed, we've seen things change in terms of where things are going wrong. And the one that happens most frequently these days is home theaters. They're fantastic, people love them. They have the integrated speakers throughout their house. They have the projectors. They have everything runs through a central location in terms of video and audio. The problem is the screen that's mounted on the wall, attached, should come with the house. The speakers that are built into the walls with the wires, built in, attached, should come with the house. All the audio and visual components that sit in the cabinet are not attached. So you need to make sure that those are written into the contract so your person can actually use the home theater that they're hoping to buy with the property. Other things that are frequently missed out, garage door openers, key fobs on condos, vacuum flow attachments, anything that's just loose and lying around. If you want to include it, make sure it's there. It is better to be overcautious than to leave it out. If there's something and you're not sure if it's a fixture or if it's a chattel, write it in so you know that it's being included in there. The attached goods. Now, these ones you think would be obvious, but people mess these up all the time. And it's not so much that they're messed up in the contract, it's that sellers often will take things they're not supposed to. So buyer seller, it's good to be clear again in the contract what's included and what's not. If your seller has said, I really want to take my built-in wall safe, then that has to be excluded because it's built in from the contract as being included with things that the buyer gets. You want to make sure that if they have an antique light fixture over their pool table that they've had for 4 generations and it's not supposed to go with the house, that it's written into the contract. This is going to drive everything in terms of what is included and what's not. So make sure you get those right. Any questions, any uncertainty, just ask your client what's their intention, write it in. Sometimes it's going to be negotiated, sometimes not. We want to make sure it's there. We have had everything come up in terms of problems on possession where things are included or not included that it's just wrong. I joke with my clients, If you're doing your walkthrough with your real estate agent and the furnace is missing, make sure that you call us right away. We'll call the other lawyer. Never thinking that's going to happen. Happened twice. My files both times where my seller took the furnace. And I want to ask them, did grandma give it to you? Was it really sentimental? Was it something that was really important to you? Obviously, it's not supposed to disappear, but we've had front lawns disappear, trees and shrubs disappear on possession days, the entire basement, the walls, doors, drywall, studs. The realtor for the seller said, oh, it's just a temporary storage room. You want to make sure if your seller is intending to take the basement, that you're right into the contract that it's not included in the purchase. That was a really unusual one, but you just want to be clear again. Everything in these contracts has to be clear, as if a person who has never ever seen the contract at all can pick it up and understand exactly what's supposed to happen. Purchase price and completion date. These are other areas where we want complete clarity. Purchase price should be an obvious one, just put the right number in. It does sometimes get messed up where people will forget to amend it. The good practice where I like to hear is the other agent said, I think you forgot to amend the purchase price because you said you were going to, instead of someone just having their client sign off on it right away. So you want to be very cautious. Don't rush that. Make sure you've got instructions from your client and you know what the price is going to be. Don't put any of this to be determined, because at that point you don't really have a meeting of the mind in terms of the contract, and it might not be enforceable. So you want to make sure that the purchase price is very clear. GST. So on most resales, we're not ever thinking about the GST. Unless it's vacant land where GST might be applicable, you most of the time, you're just going to assume that there's not going to be any GST. But it does say very clearly that any GST, if applicable, is included in the purchase price. So if you're representing a small builder, or if you're representing someone who is flipping a property, you want to make sure that they understand that their purchase price is going to include the GST. Why is someone flipping from a builder? If you're flipping from a builder and no one's actually lived in the property, the government of Canada said you're deemed to be a builder. So then the flipper often assumes that they're going to get the GST rebate. If it's not assigned in the contract, then we let our buyer clients know, hey, you're entitled to a GST rebate. They're so excited because they're getting $5,000, $4,000, $6,000 extra money that they weren't anticipating. So happy. The agent for the flipping seller, not so happy. Or if it's a small builder that's engaged a real estate agent, trademark term, if they're acting for them, then you can't, they've got to understand that GST is included in the purchase price, or else you're going to be unhappy when they're unhappy. And I've actually seen real estate agents work out the lost GST funds to their clients. So you just want to be cautious with that. In bare land, of course, because it's not a residential unit that's been previously occupied, you're always going to have GST on those. Possession dates. Possession dates, again, we need to make sure that our completion date is very clear. You can't just have it a random day down the road. You've got to make sure that the parties understand when they're going to get it and it's ascertainable. In some situations, the contracts are so open that there's not a date where they're ever going to have to close, which means it could indefinitely be held and really screw things up. You want to make sure that this date, and get the dates right, please. Next clause. The seller represents and warrants that on the completion day, the property is going to be in substantially the same condition, and that the unattached goods will be in normal working order. If your seller knows that a fridge is broken, or ice maker is broken, or the stove is broken, that should be written into the contract. That is the exemption to that rule. We're not worried about scrapes and dents and things that happen, over the course of someone living there. But most buyers, when they buy a house, and you'll know this, they see it, it's an emotional thing. They'll buy it after seeing it for 20 minutes, an hour. Whereas if you're buying a bed, you're back and forth from the bedroom shop 15 times before you buy the bed. This is a very quick process, so people don't see the stains, the chips on the wall until after they move in. Go through with your client and remind them, hey, let's see exactly what it is we're getting here. If there's a carpet on the floor by where water dishes are, look underneath. There might be a stain under there. Anything that's easy to access, you're responsible. It's buyer beware. You've got to make sure that your client understands what it is they're getting. If a seller, when they're moving out, breaks a window, that's different. Then they're going to have to repair that or replace it. If an appliance breaks the day after possession, Well, that's going to be the buyer's responsibility. There's no warranty or guarantee they're working past possession, but they have to be working on possession. I once had an agent tell his client, look, the seller or the buyer had a home inspection. Because they had a home inspection, the appliances don't have to be in working order. Not true. You want to make sure that everything is in proper working order, or it's written into the contract that it's not going to be. Some of the general terms. In this one, we're looking at the contract and that everyone's acting in good faith. So unless the buyer and seller both agree to alternative representative, that they're each represented by their own agent, and that's it. So in this case, we're looking at that there's not any extra duties going on. If you are representing both sides of a contract, then we're going to want to look at this one a little bit closely. We've had situations where people have screwed up the situation in terms of the representations. They created an obligation to someone they didn't have a relationship with. So you have a listing, someone comes in an open house, and you start providing them information, giving them advice and direction, and they rely on it. You can't then, after they've entered into the contract, say, oh no, you need to go get your own agent, because you've created that agency relationship. Even when you have the documents that say, oh, you're just customer status, or you're not really my client, but you act in such a way that creates that relationship, the courts are going to look at what was the relationship like, what actually happened. We had a situation where it was an open house, buyer came in, our client was the buyer, it was an acreage, and on title it said there was a water co-op. And the agent said, you don't have to worry about the water at all. It's a water co-op, it's fine, it's perfect, don't worry about it. On 3 or 4 days before possession, we went through the title with the client and said, you know, it's a water co-op, that's correct. But there's a water advisory on there, and the water advisory says you can't use the water that's being provided by the water co-op. Lenders don't want to lend with that. It created all kinds of problems. The deal completely fell apart, but the agent made the attempt of saying, oh, well, I'm not there really their agent, it's somebody else, they should go find someone else. Too late, can't really do that. And I want to keep in mind, back in mind, the good faith part, because that's going to be important. Everyone agrees that the laws of Alberta apply to the contract. We're in Alberta, it's going to apply here. That Alberta time applies to the contract, so everything is based on Alberta time. We're all the same time zone here, that's not a problem. But time is of the essence. So there's not this automatic ability to extend things. If you miss a condition date, the contract's dead. If you fail to waive on time, there is no contract. So if you send in the waiver after, the seller can say, sorry, we're finding a new buyer. It's dead. You can't amend it, because you can't amend it something that doesn't exist anymore. You got to basically do the whole contract over again, reprint it, everyone re-sign it. When they do that, just take out the condition if it's meant to be waived anyway. Business days. This one's changed a little bit over the years, and people forget about that. As lawyers, we can close on any day. It really doesn't matter. If it's on a Sunday, we can close the Friday or the Monday. You can pick the day. At the end of the day, we want what's best for our clients. You should want what's best for your client. But there may be interest payable. There might be little nuances that your client may or may not be worried about. There is not a reference anymore to land titles or the banks. So business days are business days. You want to make sure that where you're closing, your client understands what's going on in that, and they can always ask us. That's what we're here for as lawyers, is to help people understand. Again, reference buyer, seller. If you have more than one party and there's a reference to a seller, it's fine. It just means that it's one and the same. We may have just one seller it talks about seller, 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 and there's 3 parties. You don't have to change it to write sellers. It's just included. Material latent defects. This one is great. So we had a huge shift in this contract back in 2016. The previous rule about material latent defect was that there was no definition. We now have a definition in this contract. So if you look at this one, it says that a material latent defect means this is the definition, a defect in the property that is not discoverable through reasonable inspection, and that's basically what the old rule was. But the new part is, and that will affect the use or value of the property. We have years of case law of the old definition. Now, it wasn't defined in the contract, so definition was what the court came up with. The court heard cases, came out with rulings and judgments, And so we as lawyers, when we're having a fight with someone saying, what is a material latent defect, we look at what the courts had ordered in terms of different situations, different items, different kinds of defects to get that rule. The contract, when it was changed in 2016, changed that, well, it actually included a new definition and changed from what it was before. So all that old case law isn't really as applicable anymore, and we're gonna have to wait for all kinds of new case law. This whole idea of value of the property, that can be huge because all kinds of things can change the value of the property. You're going to see later on how it's important to disclose this. And you know what, I'm going to say it twice because it's super important. Disclosure has to be in writing in the contract. And we will go through this again. But in writing in the contract means actually in another terms section of the contract that you include that there's an acknowledgement by the parties of the material latent defect. Without that, your seller can be sued for failing to disclose under the contract, under the terms of the contract, any material latent defect. So posting it in the realtor remarks doesn't count. Sending an email doesn't count. Telling them on the phone doesn't count. Has to be written into the contract. So keep that in the back of your mind. And there's kind of like, how do we know if it's a material latent defect? My general rule is, acting for a seller, is you want to make sure, and a buyer would probably agree with this, is you want to make sure that you protect sellers. And our job as lawyers, and your job as real estate agents, is to educate. So let them know what the rule is, what they're supposed to do, and two, what the consequences are if they don't follow those rules. And then they have to make a decision. If the decision is one that you're ethically not okay with, so they're hiding something that is potentially fatal, don't take the listing. It's not worth it. Your reputation is not worth it. No one deal is worth it. No one dollar is not worth it. If it's something that it could go either way, make sure you paper your file, that you've got clear directions from them and that you explain to them the risks. Because if they get sued later, they may try and pull you in. If you could show that you've told them that this is how it should be done, and they refuse to follow that warning, then you've got some protection. You have the ethical issue of, do you disclose or not disclose? If you don't have direction from your client, you can't. So if they say, I do not want you to do this, and you're not comfortable, you can't then just disclose. You've got to back away. And it's the same for us. If we have a client who says that to us, we've got to just back away and say, sorry, you need to find a different lawyer who's going to be happy to help you out with that. It's just not worth it. In terms of reasonable inspection, we have people who say, well, you could find it. If you have to destroy things or take things apart, or it's really not reasonable, because it's a reasonable inspection, then you're going to have a duty to disclose that. And if something that is not going to cause someone any problems and you fix it, let's say you have a problem and you fix it 100%, then there shouldn't be an issue with disclosing what that problem was and how it was fixed, because then the buyers are going to have full understanding of what it was, and they can't come back after you afterwards. Your seller has to decide, do I want to risk someone maybe not buying it or paying less, or do I want to risk maybe having a lawsuit? Again, these are one of those things that if there's any questions at all, talk to the lawyers, because we work with you and the clients to make sure that their biggest concern at the end of the day is moving their stuff into their new home. So we're going to move on from this one, but keep that one in mind about disclosure. The seller and the buyer are each responsible for completing their own due diligence and assume the risks if they don't do it. So this is the caveat emptor, the buyer beware. And almost every deal we'll see will have a home inspection and financing condition. If it's a condo doc review. Again, our job as educators and then helping clients make decisions, you may want to include more in that list. REIX has a great list, and actually our firm has created a beefed up version of it, and you can just send me an email anytime and I can send it to you, it's no problem. And basically what it has is all the different kinds of inspections that a buyer could want to look at. I won't say all of them, I'd say a whole bunch of them, a whole swag, more than the 3. And then your buyer just initials yes or no, yes or no. They can decide, do I want an asbestos inspection? It's an older house, do I want to have a scope in the sewer lines to make sure that there's not tree roots or anything? And then it's not you saying to your client, oh, just get a home inspection and that's going to be fine. And then they do that and then there's a problem they find on the road where they say, why didn't you advise me? You should have advised me. It's not meant to scare people. It's just to give them options of what they're allowed to do. Some people are concerned about engineering stuff. Some are concerned about HVAC or electrical, insurance. Make sure they get an insurance on a property before they waive conditions. Anything that they're unsure about or they want to have further information on, you can create as a condition down the road. But the due diligence process is there. You want to make sure before you put in a offer that is binding, that they understand what it is that they're getting and that they've done their due diligence. The seller will ensure the seller's representations and warranties are true by reviewing the RPR. So RPR issues, RPR issues. We have so many problems with them. The biggest one, because most things can be fixed, is that they aren't received by the real estate agent from the sellers in any kind of timely manner. The contract used to say, I think the listing agreement was like 10 days. There's a fixed time period. Now I think it's a reasonable period of time. Many times we ask clients for it. We say, oh, you've added a garage. You need to update this. They're like, why are you telling us this now? So, because, I don't know. Why didn't someone tell you about this earlier? It is, as far as I know, the only bolded piece of the listing agreement that is bold and says your whole deal can fall apart if you don't have that. You want to make sure you look it over and make sure that everything complies, that there's no encroachments, that there's not any issues, you haven't built anything, there hasn't been any changes. There's all kinds of rules on this. We can help with when things have to be updated or not. But most important is taking a look at it early on in the process, ideally before the property is even listed or before a contract is entered into. So you want to make sure that's all taken care of. And the contract is, and we'll see this down the road, very, very, very protective of buyers, not sellers, if the RPR is not up to date or if there's any kind of problems on it. So we'll get to that in a little bit. Determining non-status, so tax purposes and dower rates. So it's made the news lately where there's all kinds of lawsuits in BC because of income tax purposes. If you have a seller who is not Canadian resident for tax purposes, there's going to be a withholding tax. 25% or 50% depending on the situation. There are some lawyers who insist on 50% because how are we going to know? If there is not, and it's of the gross sale proceeds. So if after paying out the mortgage, there's not enough funds for a holdback of 25 or 50%, then there's going to be a problem that we're not going to be able to close the transaction on time. Remember, because time is of the essence, we want to make sure that we can close. That means as soon as that deal is done, that the client is making an application to the CRA for a clearance certificate. And clearance certificate is a certificate that says there is nothing outstanding in terms of taxes or what that amount is. And if there's outstanding taxes, then we pay it from the proceeds. And it isn't usually, most time it's not 25% or 50%. And you can't go by, well, the mortgage is for $400,000, the property's selling for $450,000, so it can't be anything. They could have refinanced. There could be a lot of taxes owing. So that's something you want to make sure right at the beginning so the deal will close on time. And then dower rights. Dower rights are like RPRs in that they're a consistent problem for all kinds of reasons. Quick review. Dower rights are one person on title, that person is married, and if either of the married couple have lived in the property since the time of the marriage. When I teach that at a course, almost every single time, about 3 minutes later, someone put up their hand and say, yeah, but I had a file and only he lived there or only she lived there. If either of the two people lived in the property. This is really, really key. And you want to make sure that you ask them, make sure you know their marital status. You say, oh, what is your marital status? Most people say, I'm single. If they're not, here's the problem. Single can mean not married, or single can mean socially available to date. And socially available to date but still married to someone is not work for dower. They have dower rights. We've had people 23 years who are separated, still not divorced. There are dower rights that apply, and people forget about it. They forget about it as a client, and it's not until we've asked them very clearly, when you say single, do you mean never married, properly divorced, or widow, widower would also count? Well, I have a legal separation. No such thing. No such thing as legal separation. If someone says, oh, don't worry, I've got a separation agreement, well, that's just great. But a separation agreement, assuming that it actually references dower rights, is not enough. We can go to court. It's going to cost the client money to get the waiver of dower rights, but they still have to go back to their former spouse. Dower rights still apply. It's not a general waiver of the dower rights, that separation agreement. Common law, doesn't count in terms of dower rights. It's still sort of old school, legally married. It has to be legally married people. Doing other needed research, again, they're going to have to do what they're supposed to. If there's a representation warranty in there, so if a person for instance, they're saying that they're Canadian resident for tax purposes, and they're really not sure. They've just moved to a foreign country. They're paying taxes in this tax year, but they're not sure where they're resident. And they have to do that research to make sure that the representation and warranty is accurate. Independent inspections. So here's where we have kind of that list of other things. We've talked about the RPR, we've talked about mechanical systems, property insurance, exterior measurements. Don't rely on old listings for measurements. We've had all kinds of problems with measurements. The rules have changed a little bit. It's good if your buyer is concerned that they actually measure. Give them the opportunity. You release yourself of problems of measuring. If you say to your client, do you want to have a professional come in and measure this property? And they say, I can see it. That's fine, no problem. Check box. No, don't want that. Or, yeah, well, let's get that done. What's it going to cost me? Like a couple $100? So it's really up to the client, and it's for them to decide. And other things important to the buyer. And here is where we have that communication issue that is so important to know your buyer client. Some people do not want to have a grow up. We just had a file that fell apart the last minute on a transaction because the buyer asked his agent if there had ever been a grow up. The agent said, no, never had been. Now, on old listings, it showed, there were old listings that showed that it was a grow up. It shows up all over the internet as being a former grow up. I'm not sure about the historical search. Our client said that they were told that historical search would have shown it up. I didn't actually see it myself. Anyways, there was a lot of evidence that they had been a prior grow up, and that was something that was important for the buyer. Don't just blow it off. Make sure you ask the questions, at least ask the other agent, like, was there ever a former grow up? Do that research. It's important for, if someone says, I do not want to never to have a grow up, do that extra research. Look on the CRO websites, historical searches, even just Google searches often help. If someone says, I am not comfortable living at home where there is a suicide or where there is even a natural death, then again, you, as an agent for the buyer, want to make those inquiries to the seller. They may not know the whole history of the property, but they can give you what they know of, what their understanding is, and they shouldn't lie, because that's going to be an important thing. So anything, when you talk to your client, say, what is important to you? What things do you want me to look into that's going to be important for us to be able to tell this is a suitable property? Location. The Real Property Report's a great tool for buyers before they buy, because sometimes things aren't what they appear. We had a file that ended up with, looking at a $50,000 lawsuit. Our client ended up being protected. Why? Because this was a ridge house in Fish Creek. There's a provincial boundary fence along the back of the ridge, but the property owner doesn't actually own the land up to the fence. There's about 10 meters, like a big piece of land that's not included to the property line. The buyer, through their lawyer, came to us and we want a $50,000 reduction because we're not getting what was represented by where the fence was. Our response to them was easy. Hey, the RPR was sitting with the feature sheet on the counter in the kitchen. You've already acknowledged that you had those. It was there for your client to see. If they didn't make reference to it or look at it with their agent, then you're not looking at our client because our client disclosed it and showed it. That's how important an RPR is for saving things. Yeah, it's just so important there. So your buyers want to see it. Your buyers will also want to know about registrations on title. And we often see situations where agents just don't explain it to people. And I always say it's kind of akin to, we're going to go through the house. We're going to show you, oh, here's the master bedroom, here's the basement, there's the kitchen, but don't look at it. You're not allowed to look at the kitchen before you put in your offer. The registrations on title are key because it tells people what they can and can't do with the property. A restrictive covenant can say, you can't paint the house blue. And your client in their head can say, I want this house so bad because blue, it would just be the best thing ever. We hear over and over again, I never would have bought this house had I known that, ... So if there is a utility right-of-way along the side of the property, and in your client's head they're picturing the most beautiful gazebo ever to watch sunsets, but they can't build it there, they're going to know before they enter into the contract. Go over the registration on title. The overland water drainage is at the back of the property. Those are important. All the restrictive covenants, types of fence, roofing, where you can put a garage, where you can't put a garage. Those are all things you want to make sure you go through with your client because it's really going to be important to them. Contract changes agreed in writing. will supersede the pre-printed clauses. So this is where if you add in extra things in additional terms, if you put in a term that is contrary to the rest of the contract, it's going to rule. The problem becomes where there's some kind of conflict and what the intentions of the party is. I'll give you an example. Real property report. The seller doesn't want to update a real property report because they don't want to spend the money. So a buyer can accept the real property. Let's say they added a garage or added a fence or something. Buyer says, I accept that real property as is, no problem. So now what are the intentions of the party? Is it just the RPR, or are there other clauses that are affected by this? For instance, it says that there are no encroachments. So if the garage encroaches, they're accepting that RPR as is, but are they accepting the garage as is or not? It should be written into the contract. Because if they then get an updated real property report, see there's an encroachment, they can go after the client. If someone is acting for someone who's signed to a builder, so a person's owned their house for 50 years, signed to a builder, they don't have an RPR, the builder says, don't worry about it, we're tearing down anyway. Make sure you take that out of the contract. Some people leave it in, and the builder says, it's in the contract. I want the RPR, I'm gonna need it for my development permits. Make sure it's taken out. And if a builder is planning to bulldoze the house, in that case, the intentions of the parties is probably that the encroachments don't matter. It doesn't matter if the eaves encroach into the neighbor's lawn because the house is being torn down anyway. So again, it's about finding out the intentions of the parties and then making sure the contract is drafted accordingly. Because if you write in that the buyer is going to accept whatever RPR, you don't have to deal with the RPR issue. It's the other stuff that ties in that's going to be important to pay attention to. The seller and the buyer will read this contract and seek relevant advice. That is often us or accountants. So if they have a concern about the legal aspect of it, they should call us. Again, we're here to help people. We don't even charge. Someone calls me and say, I'm using the area contract and I have a question about this. I don't charge to review it with them because it's so widely used. Builders contracts lawyers will often charge for it because they can be quite big and there's a lot of things that are drafted very much in the favor of builders versus the clients. But for the area contract, it is so important for people to know what it is that they're entering into in terms of the contract. So they can either, before they sign it, see us, there can be a condition in the contract for satisfactory review with their lawyer of the contract. You just want to make sure your buyer is aware of that before they sign things so they know what it is they're getting into. Brokerage fees. So this is just information for releasing information to the real estate boards and to make sure that everything's going forward so that there's a record of prices and possessions and numbers and all that. Just allows the parties, everyone to do that. And the brokerage will provide this contract-related documents to appointed lawyers. This is an important one because without getting the documents, we can't act as lawyers. We can't even start if we don't know who the client is. And again, it's going to be disclosing of the information, so make sure that that's put in there. And we want to make sure that it's done. Sometimes there are situations where the brokerage is not identified and it just causes problems, mostly because commissions, we don't get records of commissions and most people don't like working for free.